Um, so this is a webinar being presented by the Power in Nature Coalition. Power in Nature Coalition uh, contains over 100 different environmental groups, tribal organizations, and land trusts, all coming together to further 30 by 30 in the state of California. We have seven regional groups and several topical subcommittees that seek to uplift regional projects and advocate for 30 by 30 funding and legislation. If you haven't already joined and would like to, I will put the link for our website, the 30 by 30 project story map, and the sign up form in the chat. There we go. So as I said, I'm Tom Wheeler. I'm the executive director of EPIC. I'm also an attorney here at EPIC, although I don't really practice that much anymore now that I'm the executive director. I'm a graduate of the University of Washington School of Law. And also on the EPIC staff is Melody Meyer, who is our staff attorney. Hey, Mel.
Hey, do you want me to introduce myself?
Sure.
Okay. I'm Melody, and like Tom said, I am on EPIC staff as the conservation attorney. I'm originally from New Mexico. I'm from a tribal nation called the Pueblo of Laguna, and I graduated from UCLA School of Law in 2020, and I went on to work for the Yurok tribe as one of their staff attorneys, and then to EPIC.
And we are so glad to have Mel. She's been a fantastic addition to the team. We also have, and Mel and I were talking about this, we're a little bit nervous because we have such an excellent third panelist to join us here, Pat Parento, who is the Emeritus Professor of Law and also the Senior Fellow for Climate Policy in the Environmental Law Center at Vermont Law School. Hey, Pat.
Hey, nice to see everybody.
All right, so we're talking about Loper Bright today, the case that overturned Chevron deference. And this is also kind of a larger conversation about the conservative legal movement's efforts to hamper the administrative state and what that means for environmental groups like ours, or environmentalists like us, as we try to achieve protection and try to reach that 30 by 30 goal. So, as I said, I'm both kind of facilitator and panelist. I will start with kind of just going over some of the background of where we were once upon a time, what the law was, and this will kind of inform why everyone seems to be freaking out about Chevron being overturned. So let me do a quick share screen. And now you see my notes. There we go. All right, Chevron, no more. One of the things that is always amusing to me about Chevron is that as environmentalists, we have clung on to this case named after an oil company. So when we're disappointed about losing Chevron, there's like some irony in that, right? So to understand Chevron, I think it's necessary to understand where it came from, and that is the New Deal. So the Chevron case was actually many decades later, but it is resolving kind of a question raised by the New Deal, and that is the rise of the administrative state. So I think a lot of folks here are familiar, but after the Great Depression, FDR had a vast expanse of kind of the scope of the federal government. It tried to do more in American life. We had the creation of a new alphabet soup of federal agencies, and that made Congress nervous. The expansion of the executive made the legislative branch a little bit anxious about it losing power. Yet still, we had a New Deal majority, a Democratic majority in Congress, so they didn't want to hamper the New Deal that much either. And so the Administrative Procedures Act is kind of a reflection of that balance. It's the law that governs how agencies are to make formal regulations, the rules that interpret Congress when Congress passes a law. So Congress, in passing laws, they are not subject matter experts. They're a bunch of kind of random folks from across the country. We have dentists, we have lawyers, we have Lauren Boebert, whoever she is, and whatever she knows. So we have a vast array of folks who aren't subject matter experts, and so they'll often pass laws that are somewhat vague, somewhat open to interpretation, knowing that it will then be handed to a federal agency that will then craft implementing regulations. So, for example, in passing the Endangered Species Act, Congress left a lot of terms undefined. What is a distinct population segment? That is a term created by Congress that had no legal or biological meaning at the time it was created, and then it passed off to the U.S. Fish and Wildlife Service and the National Marine Fisheries Service how to define what that term meant. And it would publish a regulation under the Administrative Procedures Act. So this is from a YouTube video. When we're talking about Chevron, we often talk about the Chevron two-step. One of the great things about law school is that law school professors will make their students do silly homework assignments. So someone at NYU Law had their students do a music video about the Chevron two-step. So this is often how we talk about Chevron. So Chevron involves the interpretation of law by federal agencies. So the Supreme Court said in Chevron that when interpreting a law, it would do this kind of two-step test. First, they would look to see if there was ambiguity in the law, or was Congress plainly stating what it wanted to occur. So if Congress had plainly stated its intent, then that was what was binding. If there was ambiguity in the law, if a term was open to multiple interpretations, for example, then you would proceed to the second step in the Chevron two-step. In the second step, if the term is open to interpretation, if it's vague, if there's some ambiguity here, then the test would be whether or not it was a permissible kind of interpretation of the law, whether or not the regulation produced was functionally reasonable. So this had led to a lot of the legal term is deference to federal agencies. So if a term was unclear, generally you would survive. The regulation would survive because of Chevron deference. So Chevron as a case really helped support a more robust administrative state by giving a lot of power to the interpretation of the federal agency. So that's why Chevron has been important, and why why after Loper Bright, I think that there was a lot of collective anxiety amongst environmentalists about what is this going to produce? Are we going to start to have larger swings taken by the conservative legal movement at all of the implementing regulations that are kind of necessary for the health and welfare of the American people through the federal government? So Loper Bright, the case here, the facts of the case that overturned Chevron, I don't think are terribly important. And Mel, I believe we'll get into this in a little bit. But it involved a regulation about having observers on fishing boats. I think that the facts could have been any facts. This was kind of this was coming no matter what. So there wasn't kind of facts driving the law. This was a long-term project of the conservative legal movement to overturn Chevron. So what's left after Loper Bright? The case seems to suggest that we'll return to something called Skidmore deference, and I put deference here in quotes because it's not kind of the same thing as we had as Chevron deference. So Skidmore basically says, we will take the regulations and the interpretations of the agency as kind of a piece of evidence And we'll look at how thoroughly they considered the issue, its consistency, um, things things like that when considering whether or not a regulation is permissible. So far less power is being given to the federal agency, and this has been a retaking of a lot of power by the judiciary. So we will talk about strategies for kind of confronting Chevron or confronting Loper Bright and how we can live after this moment in this webinar. I wanted to turn it over, though, right now to Melody Meyer to talk about how Loper Bright, this case, kind of fits into this larger trend, this attack by the conservative legal movement on the administrative state, because this is not an isolated case. This is part of a broader pattern.
Yeah, thanks, Tom. That was a really good overview of Chevron as well. So thank you. So to explore like the nuances of Loper Bright, I thought it would be interesting to kind of take a closer look at how orchestrated Supreme Court cases are. And like Tom said, how it fits into this larger historical and political climate around environmental regulation specifically. So let's start with the law firm litigating for the plaintiffs in Loper Bright, which is Clement and Murphy. The attorney is Paul Clement, and he was a Bush administration Solicitor General, and he also clerked for Scalia. Clement and Murphy specializes in Supreme Court litigation, and they have mostly represented corporate and politically conservative interests. Some of the cases that they've won include Burwell versus Hobby Lobby. They represented Hobby Lobby to limit health care provided to their employees based on a religious freedom argument. Facebook versus Do Good, where they represented Facebook in narrowing consumer protections, and City of Tahlequah, Oklahoma versus Bond, where they represented city police in securing qualified immunity. So if you were curious about how these kinds of lawsuits are funded, we can actually look at one of the organizations that Paul Clement is a member of, which is the Bradley Foundation. This foundation gives grants to organizations whose mission is to push forward either conservative political goals or deregulation generally. So, for example, they awarded grants which fall into categories of principles. In 2023, they awarded $7 million to projects that fell under the category of free markets. And this is described on their website as ensuring future generations have access to free enterprise systems and economic freedom. So it seems like these kinds of funding campaigns have been working. We see under the Roberts Court in particular, the court is working its way backwards from its desired conclusion and is sort of creating its own logic in order to not follow these sort of long-standing foundational principles of our legal system. And this, of course, is resulting in Supreme Court case law that blocks environmental protection efforts. So in February 2016, the Supreme Court did something that it had never done before. It issued a stay halting Obama's Clean Power Plan. And the Clean Power Plan would have set limits on the pollution from power plants, which is one of our country's biggest emitters. And it was supposed to go into full effect in 2030, but as we all know, that didn't end up happening. And so again, the court has never granted a stay of a generally applicable regulation pending a lower court's review. And this eventually leads into West Virginia versus EPA, which is where the court held that Congress hadn't delegated EPA the authority to approve the Clean Power Plan. The court said that EPA doesn't have the power to limit emissions in this sort of sweeping manner that the Clean Power Plan wanted to. And so, as you may recall, the Clean Power Plan was prompting coal plants to shift part of their generation to either natural gas or renewable energy. And this would have been a huge, really debilitating cost to some of these coal plants. To make this ruling, the court tapped into the major questions doctrine. And this was brought up by the Trump administration during their own review of the Clean Power Plan. So the major questions doctrine is this thing saying that courts make an assumption when interpreting a law, and it's the assumption that Congress does not assign the executive branch and its agencies decisions of, quote, vast economic and political significance. And this assumption is rooted in a theory of constitutional separation of powers. And yet, it has been largely criticized as an assumption because our modern day government does not operate the same way it did 200 years ago, as Tom was saying. Our executive branch operates at a massive level. Nonetheless, the court relied on the Trump administration's rationale, even though they had used the defined test for statutory interpretation, including the Chevron two-step test, for all of the cases that the court was citing on the major questions doctrine. In West Virginia versus EPA, the court's cherry picking of certain definitions and understandings is on full display. And so they do this for things like economy, science, technology, to ensure that the EPA could not essentially kill the coal industry. They couldn't make these substantial changes to energy production or addressing climate change. So all that is to say, while it's really shocking that the court has overturned a landmark case like Chevron, it's not really a surprise, as this has been the modus operandi of the court for a really long time. Let's kind of hone in on one more aspect of Loper Bright for the moment, which is why did they choose these plaintiffs, right? The plaintiffs are, of course, these groups of commercial fishermen, and they were characterized in their writ as 4 family-owned and family-operated companies who are facing this, quote, impossible financial burden of the observer on their boats and on their small business. So this is what is known as plaintiff shopping, and it happens for a lot of cases that are headed towards the Supreme Court. The attorneys are trying to choose a really sympathetic plaintiff, which doesn't really matter to the Supreme Court justices, but it does matter to the public. And so the attorneys are trying to make sure that if they win, the public will sort of accept the decision and see it as really reasonable. It's all about sort of crafting this story and this narrative. The problem is that even if you do find these fishermen plaintiffs sympathetic, the plaintiffs aren't really indicative of the full picture of the industries regulated by agencies, right? Banking, healthcare, agriculture, automotive, pharmaceuticals, and of course, energy. So the idea of the free market narrative blurs the fact that these industries will likely benefit from Chevron being overturned, and we as a nation will be farther away from facing these challenges like climate change and habitat loss. So to wrap up, I'm going to touch on how the Loper Bright decision impacts areas of law and policy that I'm really passionate about and invested in, that EPIC's really invested in, which I generally refer to in my mind as environmental justice. So the Clean Water Act, Clean Air Act, NEPA, these are all laws that agencies like the Environmental Protection Agency have been charged with administering and filling in the gaps of those laws with their expertise, which they often rely on from both communities, disadvantaged communities, and tribes, especially on environmental justice issues. And so this is kind of left unsaid, but in my view, environmental justice regulations can protect those who don't have a voice as loud as the regulated industry. Consumers, general members of the public, and the environment itself as well. In my eyes, the federal government's work to acknowledge and implement the expertise that tribes have in environmental management and environmental protection, that in itself is environmental justice. Because these concerns have been ignored historically, and it's only through decades of struggle that they're finally being heard. And unfortunately, decisions like Loper Bright are limiting the authority of agencies to consider and try to problem solve these environmental justice issues. So one more case example is Sackett versus EPA, where the Supreme Court held that the term waters within the Clean Water Act refers only to geographical features that people ordinarily understand as streams, oceans, rivers, lakes, and adjacent wetlands only means waters that are connected to those through continuous surface connection. So this term waters isn't defined in the Clean Water Act, and it was presumed that Congress left this gap sort of intentionally because there's so much criteria that needs to be developed by experts to evaluate the nature of what is being regulated. So the Supreme Court is saying that EPA's interpretation of waters was too expansive. And again, the definition of waters matters here because it's the trigger for permitting under the Clean Water Act, and it's sort of the trigger for EPA's jurisdiction. So being from New Mexico and being from a tribal nation in New Mexico, this decision really frustrated me because tribes in particular have a history and traditional ecological knowledge about the seasonality and the intermittency of water. We have dry farming traditions. We have maintenance of acequias, which provide water to our crops and ecosystems. And so this decision really made the justices look silly because they don't want to admit that they aren't scientists or experts in water and hydrology. And so on its face, it seems like a pure science issue, right? But in fact, a lot of tribal nations and tribal advocacy organizations submitted briefs for this case because water in its many forms is critical to ecosystems that Indigenous people have been stewarding since time immemorial. And any hydrologist could tell you that waters can be connected in different ways other than visual surface connection. And there's a lot of reasons why you would want to protect surrounding waters in order to protect another. So this case, like Loper Bright, is explicitly about protecting a free market ideal. And the story is that these poor developers had no way of knowing that they were filling a wetland. And so they had this expensive permitting, this regulation kind of sprung on them out of nowhere. And the court actually refers to the Clean Water Act as, quote, federal police power exercised in the most aggressive way possible. And so this framing really trivializes the importance of bodies of water and compared to interests and, of course, property rights. And so it turns out that the court is again making up its rationale to serve its desired outcome. And this has scary repercussions for environmental justice and climate change. And unfortunately, I think we're probably going to see more of this sort of boldness from courts and sweeping down and knocking down sweeping changes towards these issues after Loper Bright.
Thank you, Melody. So we've talked a lot about how this appears to be kind of a product of the conservative legal movement, that this has been something that they've been championing for many decades, a rollback of the administrative state, among other things. I'm going to turn to Pat now to talk about what the environmental movement can do, how we can respond to Loper Bright, and what's next for us in moving forward. Pat, want to take it away?
Thanks, Tom. And thank you, Melody, for that excellent presentation. Yeah, so to underscore the points that this is an all-on, full-on assault on the, quote, administrative state, there are no less than 6 major Supreme Court decisions from the last 2 terms. We've already mentioned West Virginia and Sackett. I sent Josephina a list of the 6 decisions and the holdings, which maybe she will or Tom will share with the folks on this webinar. And it's just a brief reference to the cases. And if there's more questions about the cases, I'm more than happy to respond to email queries about that. But I think what I would say, the take-home message from this is that federal environmental law, for all intents and purposes, is frozen. And it can only get weaker. And that's because, as this group knows, we don't have a functioning Congress. You see, because Loper Bright was based on a statutory interpretation of the Administrative Procedure Act, Congress could fix it tomorrow. Congress could amend the Administrative Procedure Act to reinvigorate the Chevron doctrine, or modify it, or do whatever a majority you could get to vote for it wanted to do. But it could restore the ability of Congress, because Loper Bright and these other cases are actually as much aimed at Congress and limiting Congress's authority and ability to delegate authority to expert agencies, do the things that Congress can't possibly do. So if we had a functioning Congress, we could fix Sackett, we could fix Loper Bright, we could fix West Virginia, but we don't. And it doesn't look as if anytime in the near future are we going to get to a point where we would have a working majority in Congress to remedy some of the problems that the courts are giving us. But it is something for environmentalists and others, many others, to take really seriously. I think more than litigation, which I've done my whole life for 50 some years. I know I don't look it, but I really think it's an electoral issue now. I mean, and trying to get the right kinds of candidates running for office, maybe some of the people on this call even should think about that, and then supporting the hell out of them and getting them elected. I honestly think that at the federal level, particularly, if we can't get the kinds of people in Congress that are intelligent and thoughtful and caring and wanting to do something about these problems that are getting worse all the time, we're just not going to be able to make the kind of progress that we need. And a corollary to that is the reality of the limits of EPA and the Department of Interior and Department of Energy to advance some of the goals of the environmental movement, climate, biodiversity loss, and all the rest, means having to put more focus on the states and strengthening state laws. I mean, Melody mentioned Sackett. EPA's estimate is 80% of the waters that used to be protected under the Clean Water Act in New Mexico are no longer protected. 60% of the wetlands in the United States are no longer protected under federal law. In a stroke of a pen, that happened. So that means if there's going to be some protection for these waters and wetlands and other resources that we care about, it's going to have to come from the states. But here's the problem. You got the red-blue divide in the states, which is pronounced, right? I'm not telling you anything you don't know. So 25 states have laws on the books saying their clean water and wetlands rules, their water quality and wetlands rules, can be no stricter than federal. So when the Supreme Court knocks out federal protection in those 25 states, it automatically knocks out protection at the state level as well, unless those states can mobilize political support to fill the gap and step up and protect those resources. So a big challenge, frankly, is going to be looking inward at the state level and then regional level, because these problems obviously don't respect political boundaries. You're talking biodiversity, you're talking landscape scale needs for management and restoration of habitat. And with climate disruption, we know that ecosystems are moving and shifting, migratory patterns are being disrupted, and all the rest. So we know that the whole way in which we think about some of these issues has to change from local level to not just state level, but regional, and then global for climate disruption. Oh, having said that, let me now revert back to my lawyer approach and say, what do we do with Loper Bright now that we know Chevron is no longer available as a mechanism to uphold agency regulations that we like? And I've had a love-hate relationship with Chevron, I have to be honest. I mean, I've lost a lot of cases that I should have won because of Chevron, frankly. So one thing people need to think about, and I know there's a lot of conversation among the public interest litigation community about this, is, okay, if agencies don't get deference, then we'll start suing agencies for exercising interpretations that they no longer get deference for, that we don't like. And even with the Harris administration, and yes, we're going to get one, I think, hope, there's going to still be interpretations that we, the environmental community, are not going to agree with, even now. I mean, look at what the Biden administration has done with oil and gas development and export, right? So we're not thrilled at everything that Biden has done. We like a lot of what he's done, and I think we like a lot of what Harris and Walz would do. But there will be times when we won't agree with their decisions, and the fact that they no longer get automatic deference—that's what Chevron created for reasonable, as Tom mentioned, reasonable interpretation of ambiguous statutory text. That cuts both ways. Now, I wouldn't overstate that because, for the reasons that Melody said, some of these conservative judges, Trump-appointed judges, think Judge Kane in New Orleans, for example, he has issued 5, count them, 5 pro-industry decisions that are frankly outrageous, and I can send you those as well if you want to see them. So I won't say that the fact that an agency isn't going to get Chevron level deference necessarily means that the environmental position is going to win, because a lot of this obviously has to do with the facts and circumstances and issues in individual cases, but a lot of it has to do with which judge gets the case. And there not only is there plaintiff shopping, as Melody mentioned, there's obviously forum shopping. I mean, why do all of these cases end up in New Orleans? Because they're sitting in the Fifth Circuit, which is the most pro-industry circuit in the country. Why do a lot of these cases end up before Judge Kaczmarek in Amarillo, Texas? Because he's a Trump appointee. So forum shopping, plaintiff shopping, finding Trump judges, finding conservative judges is going to be a problem. And the fact that Biden has been able to offset and appoint a lot of more progressive, I would say, probably more moderate would be more the appropriate term for that, judges, is helpful. And with a Harris administration, we could build further on that, assuming we have a Congress that will confirm the appointees. But that's a slow process as well. But my point is, you can use the argument that agencies are no longer entitled to automatic deference to your advantage in some of these cases. A couple of other things about Loper Bright. Chief Justice Roberts' opinion was clear that agencies are still entitled to a deference on fact findings, on factual determinations. This is really critical. So when you're thinking about how do you argue for a rule or a decision or whatever it is that you're arguing, you're advocating for, hammer the facts. I mean, that's an old proverb in litigation anyway. When always, if you can do it, always hammer the facts. A lot of these issues are mixed questions of law and fact. And on that point, Roberts had a little bit of helpful language in his opinion. He said, if Congress has delegated to the agency the authority to define certain terms, if that kind of delegation is visible in the text of the statute, or can be reasonably inferred in the text of the statute, that's another area where Roberts is signaling the courts should not override the agency's interpretation. And as Tom mentioned, it is clear, I think, from Roberts' opinion that Skidmore deference is now the standard. And Justice Kavanaugh probably captured it best in his colloquy at the oral argument on Loper Bright when he said, so you're talking about, this is a question to Solicitor General Prelogar, so what you're talking about is the power to persuade, not the power to control. And she said, yes. And I think that's the way to think about Skidmore deference, is the stronger your argument in favor of the interpretation that you're proposing, and the more that it's based on facts and expertise, the better chance you're going to have to prevail. No guarantees, but the better chance to prevail. And kind of the catchphrase that captures this whole new way of thinking about statutory interpretation is best reading. That appears in all of these different decisions. It's what the courts are looking for when they're looking at statutory language that isn't crystal clear, and a lot of times, most of the time, it's not, is what's the best reading of the statute? And so in that context, bringing in history, bringing in, and even though the conservative justices are not fond of legislative history, you find them looking at it in every case. And so, use it, right? So what you want to do to avoid the West Virginia major question trap is to say, this isn't new. This isn't a brand new, out of the box idea or interpretation. Find historical antecedents of the way an agency has interpreted the language in other contexts and relate that to the way you're now arguing the language should be interpreted. So it's not new. It's not the elephant in the mouse hole, as sometimes the conservative justices refer to the major question doctrine. And having the agency, if you're flipping over to what should the agency attorneys be doing now, and I was with EPA as regional counsel for many years in New England, they're going to have to do a whole lot better job of building administrative records that show that this thing isn't brand new. They've been consistent over time in the way they've interpreted this language. They've interpreted it in various contexts. It's in their wheelhouse, right? It's not regulating the energy system of the United States. It's regulating power plants that pollute the atmosphere and pollute the air around them. So you have to be aware of what these conservative justices, what their framing is, and watch out that you don't, run afoul of the way they think about the way statutory language ought to be interpreted. See if you can't actually make an argument that they will have a hard time rejecting, because it's common sense, it's sensible, it's based on historical applications and so forth. So I think maybe I shouldn't run on too much longer because I want to give some time for Q&A here. But what I would say is, I think the world is getting more difficult for us to advance environmental objectives. But so what? It just means that our work is just all that more important, right? And the stakes couldn't really be any higher. And quitting is not an option. So get over it, I guess, is the the advice, and be smarter about how we go about advocating for the outcomes that we want, and pay attention to what the conservatives are saying and try to address their concerns as best you can.
Thanks, Pat.
Yeah.
That was a wonderful uplift there at the end. All right. Well, friends, we have two smart folks and myself on this call who can answer questions should you have any. And if you don't, I can always throw questions to Melody and Pat. And feel free to come off mute and just ask your question.
Do any of you have hope that with the Harris Falls victory in November that we're going to have more, how can I say it, solid action towards the climate and environmental protections?
Melody, you want to take that on? I'm happy to if you don't.
Yeah, I'll just add a little bit. I am hopeful that Harris being Biden's vice president, she'll sort of continue on these like really big pushes with the efforts to transition to renewable energy, address climate change. In my little world, I'm really hopeful about all of the efforts towards co-management with tribes, tribal stewardship. So we can't change what the Supreme Court makeup is like right now. So that's sort of the downside of, if the administration tries to make big sweeping changes, will they just get immediately, blocked?
Yeah. So I think the congressional races are the key to what happens in the next term or next administration. And, you know, I mean, I don't want to sound Pollyanna-ish, but it's very encouraging that the polling is showing that Harris Wall's ticket is having down ballot impacts that in the battleground states. And although the Senate is going to be a heavy lift, I think there are at least 6 very vulnerable Democrats in the Senate, and it would be a small miracle, I think, if all of them got through. We've already lost Manchin. I don't know how that wasn't a huge loss, but it was in terms of having control of the Senate. In the House, what I'm seeing and hearing gives me a little more hope that the Dems could take the House. If they could maintain at least the split in the Senate and take the House, that would give the Harris administration room to move legislation that we need, building on the Inflation Reduction Act, the infrastructure bill, and strengthening the Clean Air Act and others. The Clean Air Act is our major federal law on climate pollution. So, you know, we need strengthening amendments there. So that really is going to depend on the outcome of the full down ballot elections, I think, in November, as to how much the Harris administration is going to be able to do to move the ball. The alternative, of course, would be utter disaster. So there's that.
I will
Thank you.
reinforce what both of the previous speakers said. Congress is going to be really important. We've seen the Supreme Court really eviscerate many Biden administration executive orders and regulations. So if we want to have kind of a lasting victory for climate, we're going to need to get legislation passed. We won't be able to really do this through administrative rulemaking in the way that we had previously attempted through some of the clean air rules. So yeah, go out and beat feet and knock on doors. And I don't think that this we can endorse any candidates here, or I can't as the executive director of a 501c3, but I think you know where my heart lies.
Call your families in Michigan, Wisconsin, Pennsylvania. I mean, the Environmental Voter Project, you all know about that? That's a really valuable resource. I mean, they do really good research on if everybody who says they vote on climate actually votes, we win. So there's a real problem with turnout. Even people who claim to be climate hawks, according to the analysis that the Environmental Voter Project does, they don't actually vote for whatever reason. So there you go.
All right. Other questions from the group?
I have, it's kind of off the back of what we were just talking about, but I think that there's probably space in the environmental movement to take a particular interest in really boring things like filibuster reform. I think that kind of, you know, even if we get good results, you know, this November, that filibuster reform for passing some of these really big environmental sweeping things that I think Harrison Walls want to do. It'll be helpful that Manchin and Sinema are out, because I think they were the main opponents of filibuster reform, but I wonder if that's sort of something constituents, you know, including environmental folks like ourselves, could be louder about in general.
Yeah, no, there's no question that the filibuster, not only did it give us the Supreme Court we have, but it has been a problem for lots of strengthening amendments that have been, there's lots of bills that have been introduced in Congress every year to not only strengthen existing environmental laws, which, by the way, most of them haven't been updated since 1990. That was the last major amendment to the Clean Air Act. But, you know, the Clean Water Act, Endangered Species Act, I could go around down the list. There hasn't been any updates to those. And the filibuster is at least a big part of that problem. Harris hasn't said anything about that, and probably right now doesn't need to or should. But when she gets elected, and if the Dems are in control in the Senate, I think that is an issue that needs to be looked at. I don't know whether it will be.
I can see where the hesitation has been before now, or before a locked-in Democratic majority everywhere to touch any of those acts, because once you open up the door, then all of the rats come in,
Yeah,
so to speak.
yeah.
Thank you for that.
What is your opinion about the idea to expand the Supreme Court?
I would not be in favor of expanding it. I am in favor of Biden's 3 proposals for term limits, for enforceable ethical standards, and what was the third one? I'm blanking. I think there were 3 of them. Those 2 for sure. The problem with expanding the court is, boy, then you have just totally. I know you're going to say it's already politicized, but yes, and it is. But it would make that problem worse, I think. And it would require a constitutional amendment, which I don't see happening. So there's argument about whether you can actually adopt binding ethical standards, which would immediately disqualify Alito and Thomas, for example. And not only adopt those standards by law, but enforce them. And what mechanism would you use to enforce them? And what's been suggested by people smarter than me, which constitutional scholars smarter than me, I think would work, is you would create a panel of senior, probably retired judges from like the circuit courts, maybe former Supreme Court justices like Kennedy and Breyer. And they would be the panel that would decide whether or not a given member of the court had violated these ethical standards. I think that would go a long way to controlling some of the really egregious conduct. I mean, I'm ashamed, frankly, of what I see happening on the Supreme Court. So those 2, term limits and enforceable ethical standards, those are doable, I think.
I would reemphasize our previous conversation about winning elections. And that is going to be the most important thing to reform the Supreme Court. The conservative legal project took a long view and was able to get the court that they have by winning elections, albeit through anti-majoritarian ways, but they won, and they got there by our ordinary processes. I'm always kind of fearful of this fight over reforming the Supreme Court. We have very little kind of historical precedent in our modern age for reforming the court, and what we do have was a freak out at FDR for his court packing policy. And luckily time is somewhat on our side too. The 2 oldest justices on the Supreme Court are Alito and Thomas, the 2 worst justices on the Supreme Court. We win a couple elections, we will have a couple more seats in the court and we can flip it back.
Yeah, I agree. I think the political climate right now is like too tumultuous to do something like that. And what Pat suggested of something that, should be appealing to both political sides of a spectrum, I think, that's something that we need to turn towards more and think about what it would look like if God forbid Trump won and we had an administration that wanted to take the similar action, hacking the court or adding more seats. So, yeah.
Fraught. These are fraught times. We got to get our issues out of the culture war. I don't know how to do it exactly, but I get so depressed when I read the polls that say the climate really isn't a voting issue. And I still see this incredible, unfathomable divide over, is the science real? Is, can you believe your lying eyes when you look out and you see what's happening in this country every day right now? And you still, when you poll, you know, your position on climate is absolutely the color of your ballot. You know, it's just clear as can be. And it isn't like that anywhere else in the world. I spend time in Europe. I've visited as a visiting scholar or whatever in a couple of countries in Europe. These are not real issues anywhere else except here. So I don't know what to do about that. That's a big one.
I think getting money out of the equation would be a good start, because it seems like all of the corporations that are the biggest polluters make the most money. They don't have the votes themselves, but you know, it only takes somebody that doesn't believe the environment is the foundation for all living things to make it a muck. So
Yeah.
And that's due to another Supreme Court decision, right?
Right.
Pat, working with the court that we do you have any thoughts on strategy for some of our newer Supreme Court justices that that aren't as bad as Thomas or Alito? I'm thinking Gorsuch on some issues. Yeah, Kavanaugh.
Barrett for sure.
Yeah, Barrett. Yeah.
Yeah. Well, read her opinions, and she wrote a concurring opinion in Loper Bright that pulled back from some of what was being said. And so I'm serious. And I said, I mean, I would get just late Justice Scalia's book on how you convince me when you argue in front of me. So he has spelled it out. And you know, we've and with Barrett and sometimes Kavanaugh. I mean, we got Kavanaugh in the Maui case, which upheld you know, enforcement of the Clean Water Act, where the discharge goes through groundwater into the ocean, right? That was not a gimme. That, you know, we needed Kavanaugh's vote for that. So you've got to look at these justices and judges when you're in front of the lower court judges really carefully and read what they have to say, what they've either said in opinions, sometimes in their speeches, sometimes in articles that they write, and, you know, learn how they think, and try to address it. I'm not saying you're going to necessarily be successful every time, but if you don't understand your, if not adversary, the person you're trying to persuade, then you're going to be disadvantaged when you try to advocate in front of them. And some of the ways in which we've argued environmental issues in the past with a lot of passion, you know, with a lot of liberal sounding, socialist sounding approaches just don't work. So, you know, tone and style and language, those are going to become really important.
And we touched on facts earlier, and having a good set of facts for yourself when you're going to court. We've seen that in litigation ourselves when we've had a really charismatic standing declarant that can kind of expand the conversation and introduce new issues to the judge that they wouldn't have thought of, and play to their sympathies. We had an indigenous mother who liked to fish in the Klamath River, and her ability to fish in the Klamath River was threatened by a bad plan approved by the National Marine Fisheries Service. And having her declaration, I think, was the reason that we won the case, and because the judge understood the issue through her lens, and that was a really important thing. So kudos to my colleague Amber for finding that standing declarant and for kind of cultivating that relationship.
Yeah, that is a good example of what I'm trying to stress. And, you know, the more that judges, we environmentalists have a rap on us, you know, the conservative judges are suspicious of us, frankly. And the more that we can appear normal to them, the more that our plaintiffs and our clients can appear to be every person type plaintiffs, you know, real people, right? The better off we're going to be. And the more that our cases get colored or get seen as extreme, the more we're going to lose.
Okay, so the marching orders are historical reference, facts, and normalcy.
There you go. That's a start.
Okay.
I like normal in this whole conversation of weirdness these days too.
Yeah.
Make
And
them the weird ones.
USA.
Yeah. Let's take it back. All right. We are at the hour. Thank you to my fellow panelists. And thank you, audience, for joining us. The
Yeah.
webinar will be available online in case you missed anything. Give it a couple of days to get on to YouTube, and a link will be sent out. So thank you, everyone, and have a wonderful day.
Thank you. Thank you.
Thank you. Bye.
Bye.
Okay, Bonnie, you can eat now.